She started us in the morning. Yeah.
We're so sorry, guys.
I'm not.
I think
It's the
that's,
reality of the situation, and
Yeah.
what I have is I've got just some really basic entry level,
Yeah.
get yourself certified as, you know, so you at least understand
Perfect.
what's basic HIPAA compliance.
And 2013 was when the
So
most
get your little
recent
certificate
HIPAA
on it.
policy
Good.
revision took place. So you don't want anything before 2013. Because I know somebody just pulled one up the other day and was telling me it was from 2003. And I'm like, that's not gonna help you. So, and it's, just so you know, it's HIPAA, H-I-P-A-A, not HIPPO, H-I-P-P-A, like you want 2 A's, 1 P. It's like you're spelling Mississippi in a deranged way, I don't know what that means.
we're
but
happy
go
to
ahead.
work with you on this because you have a great resource right here, and I think
Yeah.
we're happy to work with you on this, so thank you for that.
Mhm.
And I think that this is something that we can come up with a set of forms, at least for the next foreseeable future, which is anywhere from 3 or 4 months to the next couple of years, should be pretty good. And but we do think you need to be HIPAA compliant. We really do. And I know that's a burden on you, but it doesn't hurt you to have it. It's more paperwork for your clients to fill out. You're in the most regulated profession, the most regulated state you could live in is right here. I mean, this is it. This passes Illinois, passes New York in a lot of ways. So this is a very, very
So if we can
regulated
do it,
state.
anybody can do it.
Well, I
That's
have a,
Important. That's important.
I do have a question a little bit. So, I mean, there's Ayurvedic practitioner. I mean, there's those of us who do Reiki, there's the massage therapist, you know, AMTA, they all say you don't have to be HIPAA compliant if you don't do the insurance. So is it your opinion that it doesn't matter, you could be a Reiki practitioner and you have to be HIPAA compliant? If you're just under the Health Freedom Act, you better be HIPAA compliant?
If you're providing health care, I don't care what it is, it's smart to be HIPAA compliant. Does that always mean you have to have the privacy policies? No, you probably should though. But we are of the belief that anybody practicing in the realm of healthcare, if you don't, in this very minute, you're about to fall under HIPAA. They are expanding it. And, you know, mental health practitioners weren't there. They've become there over the last however many years.
HIPAA struggled with this because the act was never designed for this kind of stuff. They're taking an act, the bureaucrats are taking an act that was only designed for the strict AMA medical professional, the physician, the MD.
The transferring of documents between two MDs in a hospital situation.
That's what it was designed to do. And
Exactly. And it's just gotten bigger.
what's the
and bigger
truth
and bigger.
about regulators? If they can expand their jurisdiction, they'll do it.
They like to regulate.
Now, I'm looking at a young woman over here who has a computer. The litmus paper test on HIPAA is always, do you have a computer? That's really pretty much it.
Are you
If-
talking? Yeah, that's
If
the
you're
next one.
if you're using it right, if you're
So at
using
least
a
get
Here's
some-
your other
a
one,
computer,
right here. This is your other thing. You got a
Yes.
smartphone, you're using it to talk to clients, you're going HIPAA.
that takes you under HIPAA. We've got case upon case with this. I mean, we're not
So
speaking.
again, we're gonna offer best practices.
Yep.
And then you as a practitioner have to make your choices with how risk averse you are.
Exactly.
That's it. That's it. That's all we're doing here today.
And just for the record, we're not making things up just to scare you. These are things we're seeing. These are things we've experienced within our practice. Our clinicians of various licensures, various registrations, these are things they're dealing with. Now, Colorado has no control over HIPAA. That's a federal thing. With that said, you're smart just to use it as the standard. Right? It's not meant to scare you. It's just like, hey, if you're going to talk with a client over the internet, don't be using Skype. You know, you want to protect that person.
One of the things that I like to think about is we keep talking about regulations. These are protections, right?
Yeah.
They're meant to protect the consumer,
yeah.
That's right.
but yes.
But look at the personalities, as I talked about earlier.
Mhm.
What, in the world of bureaucrats think in this little box. You're highly creative people. We're talking to the most creative people here that we talk to. I mean, you're on the cutting edge. You're highly creative. You're drawn to this. Our goal is to keep you out of trouble. And the issue is, if you have these procedures and policies in place, you're going to be out of trouble. You're going to look quite impressive to the powers that be, because you're going to whip these documents out and say, this is the standard of care, this is best practices, this is what, hey, I've been doing this for 2 years. And there you go. Because Dora asks, the first thing Dora asks for, if any regulatory action comes down, the first thing they ask for is your disclosure statement. What has your client signed? It's the first thing they ask for.
What's your client agreed to? What does your client understand?
Now, let's expand on that just a touch, then I want to get back to this. Because your disclosure statement, the one published is pretty good, but it doesn't go into your policies and your procedures. It doesn't go into your office hours. It doesn't go into emergencies, what you do when you're out of town, and so on. You need that. You need to have a policy that says, if I'm unavailable, because don't forget, your people depend on you. You have a following of people who depend on you critically. And so, in their mind, you're one of the most important persons in their lives. So they depend on you. So have your policies spelled out that really say, when I'm out of town, you may contact so-and-so. If you have a medical emergency or a reaction to something and you cannot reach me, this is what I want you to do.
I was just thinking, Heather, when you said the 20-minute thing, you were talking about somebody had said to,
Don't oil pull for 20 minutes.
okay, so
Yes.
don't oil pull for 20 minutes, this is coming from Heather, but if somebody doesn't know any better and they go ahead and do that and they have a medical reaction like something, their hives, anaphylactic shock, whatever's going on, they need to know what to do. They need to know what steps to take. You also need something that says you can't guarantee results. Can anybody in this room guarantee that a specific oil is gonna help me do whatever?
No.
Right?
Now remember the people you're dealing with. And you've got guys like me, and I'm one of these guys who, if one works, two work better. Okay, I've gotten into
Yeah.
trouble on this. Okay, my doctors have yelled at me over this because that's the way that I think.
If 20 minutes is good, 40 is awesome.
Yeah, it'll work better
Right.
because that's the way I think. All right, and I've had to cut back again and again and again because they said, "Don't do that." And I've been yelled at. So, and I have a good friend who is a naturopathic doctor. Don't take too much of this. Okay, stop it right now. And that's the way it is because you have people like that.
True.
Okay, so know your people, know their tendencies, what they do, and so on. But I think in the risk management side of things, Michelle is absolutely correct. Get ready for HIPAA and get in compliance with it because we don't know where it's going next, but I bet it's coming your way. So just plan on that and get wired on it, and you have some excellent people to help you with that, who really can. So do that. That's a good one. What else do you want to say about HIPAA?
Nothing. I'm good with
Okay.
it. Y'all got HIPAA, right?
Because it's there
Perfect.
and it's getting bigger. It's the dinosaur in the room, you know, and it's there. And we all have to deal with it. Even our law firm has to be HIPAA compliant because we deal with you. And we deal with the mental health profession.
Well, not you specifically, but
I mean,
it's because of Harrison that we have to be HIPAA compliant.
we have spent big bucks on this because the issue is we have to make sure all our systems are entirely HIPAA compliant because of you guys. So anyway, so this is the way it is. And the HIPAA people don't know how far it goes, but they want it to go. One day they wake up in their little bureaucratic bed and they think, hey, maybe this applies to the Ayurvedic practitioner. Maybe we should make it apply that way, that kind of thing. And that's the way they think. Literally how they think.
This is a day-to-day thing.
It is. We see it, and I'll tell you, we defend it. Now, Dora does not have jurisdiction over HIPAA. If you ever get a complaint, Dora, our first line of defense is, Dora, you don't have jurisdiction over HIPAA, go away. What does Dora do? Yes, that's true. And then they turn you into HIPAA. And that's what they do just because they don't like that.
Can we discuss Heather's question regarding the use of the word medical? This is the section.
Here's your statute.
Thank
A
you.
naturopathic doctor, you bet, may use the title naturopathic doctor or doctor of naturopathy or the initials ND. A naturopathic doctor shall not use the term physician, the abbreviations NM D, or N period, M period, D period. The term naturopathic medical doctor, this is where Michelle is getting excited about your name,
Mhm.
because the problem is that in theory, and it's purely theory, the public thinks when you're using the term medical that it's a physician, an MD, as opposed to a naturopathic doctor. So, right here in the statute, the term naturopathic medical doctor should not be used.
Can I ask one question of you?
Mhm.
How is COLORAMA connected to NAMA? Is it connected at all?
No.
We are an organizational member of NAMA,
Okay,
and NAMA has initiated a new, they're just beginning a new initiative to actually roll out state level organizations
okay.
based somewhat on our model.
This may actually protect you.
Mhm.
The reason I'm saying that is I used to be president of the Colorado Counseling Association, which was a branch, or still is a branch, of the American Counseling Association. By definition, we use the same name. That's why I'm asking, how closely, can you get a little closer to NAMA right now?
We're trying.
Okay, good.
Because it would grandfather in the use of our name.
Exactly, and that will help because you're named according to the professional organization nationally. Colorado can still have an issue, but you're gonna have a national backing in the event you ever had to fight that.
Okay.
So I still don't love the use of the word medical, but it is what it is.
I think it's being discussed at all levels.
Hold on, she has a question next to
So
you.
what is considered to be national level organization? I understand that it is registered as a national,
Uh-huh,
but what is that required that will protect us?
Yeah.
If it is just named, or what are their, how I can buy into them
uh-huh.
so that I will be protected? What is your,
So
are
what I
those
mean by
things?
that is a national professional organization, especially if it has branches or different state level connections, and you're following your name, so you're the Colorado branch of NAMA, you're using their name, and you're using their language and their definition.
but are they need to be like registered,
No.
licensed?
No.
They are the one who is licensed?
That is, if you have a
What is it?
professional organization that you're looking to nationally, that's who you're going to, right, is NAMA. So based on your specific profession, who is it that you look to? As an LPC, I look to the American Counseling Association. As an attorney, I look to the American Bar Association. These are national, recognized organizations that apply in general. That's the body that typically does that.
by who?
Recognized
Yeah, that is my question.
recognized by your profession. So you come in and you're saying, this is what we do Ayurvedic
Okay,
stuff, and you're looking at, we go to NAMA for our ethics codes, we go to NAMA for our directions, we go to NAMA for our
Steps
training.
of practice.
Well, we can, but there's also APNA, there is
Yes,
another,
that is my
there's
problem.
another
So there can be more than
national
one
organization.
national organization that is recognized,
Yeah.
as long as you guys are connected with one of them. I'm just saying, I'm trying to find a way.
Sure.
Yeah, if you want to
We're discussing.
continue to use the name, I'm just saying, if you can become more closely recognized with them, that is going to help in the event that anybody ever said anything. The word medical, I don't love because of the statute. I just don't, just based on how, yes.
Would it be safer to say Colorado Ayurvedic Healthcare Association?
Yeah,
That would be
But
way
even the use
safer.
of the word
Healthcare.
but healthcare is still,
But then
it's,
you're under
it's,
the then you have the Health Freedom Act, which is like you get to do healthcare, at least you'd have that covered.
it's safer than medical. The problem is, again, as Bob has said before, the AMA has such a strong lobby.
Sure.
Anything that crosses into their medical boundaries is going to be an issue. And that's where we're trying to prevent it. But I think that's something you can discuss with NAMA, because I guarantee you this is not the only state in which they're
Oh,
dealing
no,
with
it's being
this.
discussed at the national, it's
Right.
being
So
discussed.
what about just saying Ayurvedic practitioner? Is that practitioner word is not good?
So if you guys could actually then address, which I think is what Avi's asking.
Yeah.
The intent of the practice versus the specifics around the languaging. Because my understanding is that if you are intending to practice healthcare,
Yeah.
doesn't matter what you call yourself. You may come under these.
Yeah, but we need to be like,
Regulators don't care about your intent. If you are ever in a situation where you have to defend this, they're gonna look at what it says right here in a statute, what it says under whatever statute you're under, and they're gonna say, did they follow the rules? They don't care if you intended to or didn't intend to.
Right.
You did or you didn't. That's the problem. This is who we deal with.
This is the issue. You're trying to, a lot of this is, and as a trial attorney, I have a different perspective than perhaps other lawyers might. I'm used to pushing the boundaries. I'm used to expanding things. And I turn to the national organizations and I say they provide guidance that DORA does not have. They provide guidance. Now, when I sat on the board, DORA would repeatedly say on the board, the national organizations may be helpful, but we are one of 2 states, Arizona being the other one, we're not bound by them.
That is where I want
That's
to know.
exactly.
But in this situation,
That's what they say.
your regulation's not
However,
strong enough yet
Right, and this is so new and it's so evolving
that we have to go there.
that we go to the national organizations and you want the national organizations for support. Because
And
we're
some
gonna
sense of
use it.
unity.
Yeah.
Some sense of
Absolutely.
unity with the field, so we're kind of all on the same page and have the same standards.
Exactly.
By the way, this discussion was only about your name. It wasn't intending to use them to, it was just trying to find a way to help you keep the name, which is, you know, that might be a way to justify it.
So while it is not, now let me talk as a trial attorney, not as a human being, okay?
Very different.
It may be, okay, Dora may say publicly, all right, we're not bound by the national organizations. But they may think in the back of their mind when we make the argument, or you make the argument, that these are the national practice standards that we follow in the national organization, this is best practices according to our profession. You're dealing with new people over DORA, which is why we spent time talking about that. They may say over DORA, okay, you know, we really don't know, and maybe we should defer to this. That's the way they think. If it isn't down in the regs and the statute, the regulators don't know where to go. Please, I hope this tape never goes back to DORA.
Hi, Dora!
I'm giving you some trade secrets here. The idea is the fact,
Dora the Explorer.
if it's not written in the regs, they get lost real fast. That's where your national organizations come in and where they help you. And the more prominent they are, the more powerful they are. Saying the obvious, like the AMA is very, very powerful. Your national organization helps you. You know, hypnosis has been another field that some of you are familiar with. We have some national organizations that deal with that, and they've gained preeminence over the years. And Dora now looks to them for guidance. 20 years ago, that wasn't the case, but they do today. You want the same things. You want to align with a national organization that really supports you legislatively and in terms of training, ongoing training, and so on.
I would actually add to that, having run one of the state organizations, I know you guys are what, about 40 members? Is that right, more, roughly? Roughly around there. So when you are growing like this and you have this kind of passion that I hear in this room for why is this like this and why isn't this like this and what are we doing here? This is your opportunity. You guys are right at the growth part of this to tie in with that national organization, to use that and to begin lobbying here, getting a hold of senators and state legislators and growing this and defining this in a way that you want it defined, that makes sense to what you do and is not allowing somebody who may or may not have any clue about what's happening to do that for you. Does that make sense?
Let me give you an example. Here we have NAMA right here on your code of ethics and professional conduct. Listen to what it says. Under section 2, we always put the well-being of the patient before all other considerations. What's going to be your primary defense in any case? I put the well-being of my patient before any consideration I had. I wanted that person to be taken care of, and that's what I did. So we draw right from the code of ethics, and we use that in your defense. That's the kind of thing we want to do. We don't want to have a situation where someone turns around and says, well, you're at a deposition, and I pray it never happens to you, but you're at a deposition and someone says, tell me how you put the well-being of your patient in front of everything else. Okay, this is what I did. I did proper record keeping, I did proper analysis, I did a proper intake survey. I understood as a person progressed. I warned Bob Lees to stop taking 2 of the same thing and go back to 1. Because
We have record of that exchange.
that's
Exactly.
right. Have records of it, because you're,
And even
You're-
a phone call, conversation, just make a
Mhm.
date and time, I received this phone call.
I am so
we had this
sorry.
conversation.
the day of non-documentation
On.
is gone. You have to allocate certain part of your fees and certain part of your time to proper record keeping. Build this into your into your structure. Now, you all practice this. You may have an hour session with your patient or your client, however you want to call that.
Your
But
people.
but you want at least 10 minutes of that to do proper record keeping, right? So you want to cut that session, that one-to-one interaction down to 15 minutes and have proper record keeping for that time. With the idea being, should something happen to you, another practitioner can come in and can pick up your records and go from there. Now, if you're using shorthand, people have gotten into trouble using shorthand if the next guy can't understand it. Okay? Yes, sir.
So the pros and cons of recording sessions?
Well, okay, we've got privacy concerns there, and that is, if you, the rule is this, if you disclose, you can do it. The problem is with that is, I would almost never do it. Because the issue is, I don't, now you're talking to a trial lawyer, not a human being. I don't want to be bound to that recording necessarily, because I may want more flexibility to say, the recording did not capture the other things that were going on, the other dynamics that I perceived, that I read, that I drew from. So the recording captures the audible, or perhaps the visual and the audible, but it doesn't capture the nuances. It doesn't capture what is going on. That's a.
What was your purpose for doing that, Harrison? Why would you want to record somebody?
Well, obviously, it's a he said, she said situation in court, and a recording always.
But your records can do that. Good record keeping has really prevailed. When we have people who keep good records, and you're commanded by statute to keep records, and by regulation, these records prevail. They always do.
There is one time I would suggest recording, but you always have to get the consent of the person.
Yes.
So they know how this is being stored, where it's being kept. One profession I really recommend is hypnotherapy. Particularly something like regressive hypnotherapy, or something where the person,
Past retrogression.
yeah, exactly, where their eyes are closed, where they're laying down. But I will give you a little, little story. We had somebody do that. It wasn't here, it was back in Washington State. And they videotaped from here up, and there was an allegation of sexual conduct from here down. So it's one of those things that you have to be very careful, in your intent. It can work against you as well. You can say, no, I didn't say that, but somebody else can listen to it and say, oh, but that's how I heard it too. So it's kind of it depends on your situation, and if it's necessary for training for students, that may make a lot of sense. But again, you need to have some sort of consent from the individual, informed consent.
Colorado doesn't require that.
It doesn't matter if Colorado does, your attorneys do. This is what we're just saying. If that's something you want to use, I don't know how the training goes. With therapy, we do recorded sessions when we're practicing, so we can see what we look like and what we're saying. So it may not be the practice here, and that's fine. But if you need to have a student or a client or whomever say, look, I get this is being recorded, this is how it's being kept, this is where it will be kept, this is how long it will be kept. And this is what it'll be used for.
And on a practical level, does it inhibit the interaction between you and your client slash patient? Does it inhibit that? Now, we are 5 after 11.
It's okay, we have time, right? Are you okay? And how about you guys?
I just have to be done by 11:30,
Okay,
so.
whatever.
Okay.
I mean, I'm okay. It's.
Do you want to have a short break for a couple of minutes?
No.
You've been here-
Is everybody okay to push through to 11:30?
Yeah.
Let's just do that and then we'll
Okay.
do as much as we can.
Okay, sounds good.
Bob, I have some water for you in case.
Oh.
Oh, thank you, I have a little bit, I
Do you,
appreciate that.
do you guys have other, I mean, we're talking a lot about this stuff, but I think there are probably other very targeted, specific questions
Yeah.
that we may not be reaching. I want to make sure, oh, I'm good, thank you.
I just want to know, there was this about not touching our clients, we cannot touch our clients.
Yes,
The contact, like medical doctors.
right?
And so with us, I mean,
What does the statute say?
what does the statute say?
So the naturopathic doctor statute, if that's where we're going, says that,
I think the two are health freedom
right?
and the natural.
Right, so I'm gonna
Massage
start with,
therapist.
okay, well, a massage
No,
therapist,
that's
you're gonna
all.
touch your client. I'm not worried about that way.
No, but if somebody, where you could run afoul is if certain kinds of touching
Right.
Oh, we know.
could be massage.
We just had
We
somebody
just had a
completely lose his
case on
license.
this, we just had a case on this.
Yeah, we get a lot of stuff with massage, inappropriate touching. So here's the thing about touching in the health arena.
Thank you so much.
The biggest thing that you will know, no thank you, is that,
Thank you.
well, sex with any kind of client is absolutely forbidden. Okay, period, end of story, don't do it, stop, don't think about it, ignore it, you didn't hear it, you don't wanna do it. That clear enough? Don't do that. And you guys look at me like, okay, why would we ever do that? Well, our therapists do this all the time. Our doctors do this fairly frequently. The difference is statutorily within Colorado, mental health professionals can't have any sort of relationship with their client outside of the therapeutic relationship for 2 years. The naturopathic doctor statute says 6 months. From the time you have to sign a written termination, and then 6 months after that, you can then interact with your client slash patient. Now, here's the thing.
Your competitors are not happy with that.
That it's such a little bit of time.
That's
Yes.
right.
So the deal you have to understand, in our world, in the world of mental health, and I'm coming from a very specific place, is once a client, always a client. Because there will always be, and the same thing with what you guys do, there's always gonna be a power differential. I'm coming to you because I need to relieve the symptomology, and you're the person who can do that for me, and so you're gonna be the person who fixes everything for me. So that relationship will always have a power differential. Some people can get past that, yeah. In terms of touching within session, if it is something along what you would actually do. So, for example, we have people, do you guys know what EMDR is? Okay, so there are practitioners out there now doing EMDR in which they're touching shoulders and heads, and they're actually relieving migraines. So what we have done to alleviate that is, in the disclosure statement, we say, there may be a time where we need to do therapeutic touch. You have the right to opt out of that. As long as that person knows that he or she does not have to, and I'm using he or she for anybody in here who prefers more gender-neutral terminology. I'm just using gender typical for purposes of the discussion, but if that patient or that client doesn't want to be touched and tells you, I don't want to be touched, and you ask, is it okay if I touch you on your knee? You went to your knee immediately, so, and explain the purpose, that's one thing. If you go and you're trying to touch various other body parts, I've had I'm sorry to my massage therapist, I love massages, but I have had massage therapists expose me. And it's very uncomfortable, and it was a male masseuse, and I'm like, stop, you know? So that's, you have to be very aware of who you're dealing with, and when it's appropriate, when it's not, based on your training and your skills. And allowing that person to opt out.
That's the issue. Get permission.
Always.
If you get permission and disclose, you're okay. Obviously, never touch the wrong part, or private part. Let me just touch on something for a moment in answer to your question a little bit here. I'm looking at grounds for discipline here, and you're ahead of other professions. Listen what it says. You may be disciplined if you engage in an act or omission that does not meet generally accepted standards of practice of naturopathic medicine or of safe care for patients. And the statute lets you use patients, it's right here. Whether or not, now listen, here's the regulator coming in. Whether or not an actual injury to a patient is established. So they say even if the person wasn't hurt or harmed, you can be disciplined, but it gives you permission. You must meet the generally accepted standards of practice. Who determines what that is?
For
Any
us,
ideas?
NAMA.
For NAMA, and also the Colorado professionals that practice this together, right? Unless you're doing something like rebirthing.
It would be
But-
great in this state if when you went before a board, or you went before a hearing officer,
We could reference our standards of care.
Exactly.
you reference your standards of care, that's what you
What
do.
about doula,
And that's what,
Ayurvedic doula,
Oh, the doula practice.
doula practice?
Mhm.
and that's why that's so important to have that connection to the National Association, because it helps you establish, the statute gives you permission right here to do it.
This is the ND statute, just to clarify.
Now, our therapists do not enjoy that because Colorado can choose whether or not to accept the national standards or standards of care. It can decide on an ad hoc basis. This is why we're so frustrated with DORA. It decides on an ad hoc basis what it's going to allow and not allow.
Based on the personalities in the room at that
That's,
moment.
you've got it, and that's the issue we have with that.
Another question is, I have these two professions.
Yes, you
I'm
do.
licensed in mental health,
Mhm.
and I'm an Ayurvedic
Mhm.
doctoral quote practitioner, whatever that is.
Mhm.
Where is my line?
So that's something that we need to have a conversation with you about, because it's gonna depend on how you're using each arena, how you're blending them, if you're blending them. In some ways, I would say like coaching. You know, you could use a coaching skill, but if you're actually gonna do full coaching, we would have you do a separate business. So there are different ways, so we need to have a conversation with you
There's a
about that.
reason for
And I've
this.
spoken to Medicaid and BHI about it too, and they,
Exactly.
Yes,
Yeah.
there's a reason for this response.
okay.
It's because both boards will want jurisdiction over you simultaneously.
Mhm.
We don't want you facing that. It's situated, we want to divide it so you're accountable to one and not the other. Because if we get two of them interacting,
Right.
our defenses can actually conflict, in a sense. You can have conflicting approaches.
Well, like you can't touch in therapy typically, right? So if you're doing something that requires, that's where things get messy.
Well, you just keep them separate.
Exactly.
Now, another thing is that you have to be, and I'm saying the obvious, you're ahead of me. Another thing is, you have to refer out when a situation exceeds your competence, or when you feel, what's the one situation you always refer out?
Suicidal ideation?
That and cancer.
Well, yeah, and if we're gonna say that, then we're also referring out pediatric care for infants
Exactly.
and mother